Welcome, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the CEO and founder of SERMA, Rich Lenkoff, and I'm also the host of the SERMAPod. And we're very privileged to have Barry Chase from Chase Lawyers join us today. Barry's a South Florida attorney, well conversant in all issues dealing with First Amendment, entertainment, sports. Barry, welcome to the podcast.
Thanks, Rich. Thanks. Glad to be here.
So Afroman, I haven't heard of Afroman really for about 20 years or so, since the seminal hit, Since I Got High came out. That was a early 2000s hit. And he's been working steadily, apparently, but he's in the news recently because he is the subject of a lawsuit by some police officers in Ohio. The story goes that they were serving a warrant, and they entered his property, and this is captured on both body cam video and surveillance video that the rapper provided. And on video, we see the officer searching his house on a kidnapping and drug possession charge. And they ultimately, it should be noted, they did not pursue charges against him criminally. After this warrant was served, the rapper released a song that details their escapades. He is showing the officers rifling through his suits, saying, are there any kidnapped victims in my suits? They're looking through his CD collection. They're looking through his entire house. Notably, Barry, at one point in his kitchen, which, by the way, looks like a beautiful house, we see some lemon pound cake under some glass, and an officer stops and takes a look. So Afroman releases a song detailing this aborted or failed search that didn't result in any criminal charges. And he talks in the rap about the search. He releases a video, very notably as well, in which, for the most part, you cannot make out the police officers' faces. He also releases on his website a T-shirt involving a character from Family Guy, the show Family Guy, Peter Griffith, alongside a picture of the now famous, infamous pound cake, lemon pound cake, as well as the officers. This results in why we're talking to you today. They filed, as I mentioned earlier, a lawsuit against him with various allegations. Why don't you pick it up from there, Barry, and tell us what these officers are alleging in Ohio, understanding that neither you nor I are experts in Ohio law. We don't practice in Ohio, but generally, what are they claiming in this lawsuit?
Well, they're claiming some things, and they're doing it partly strangely, but they're claiming invasion of their rights of personality and privacy. Now, each of us has, by virtue of just being individuals, the right to control the use of our image, our life story. That's why you have life story rights agreements in movies, for example. Our signature, certain aspects of our history that are not in the public domain. And these officers are saying, well, you know, the fact that he has made actually a couple of music videos, which are not so much raps as they are simple tunes, but either way. A couple of music videos that deal with this, one having to do with the lemon pound cake, which he claims is his mother's recipe, which is quite endearing, and the other having to do with just the destruction of some of his property and who's going to help him pay for what they did. And in fact, these are problems in society, in that if you get raided by the cops or the FBI or anyone else, you're not going to get reimbursed for whatever it may cost you to, you know, fix the broken door on your house, to in this case, to fix his home video recording system, which the cops decided to disconnect, which is in itself an interesting, raises interesting questions under the First Amendment, because they're in pursuit of their official duties. But without getting into that side of it, what they're claiming is that he is using their images, their rights of personality, which, as I say, includes your image, includes what you look like, and includes your name sometimes. He's using those things to make money, they say. And they never gave him a license to do that. Now, query, as we lawyers say, which means question, whether they're entering his house, which is a location that, but for the warrant, he could keep them from entering. That's why we have location agreements and in music videos and in films and things like that. They entered his house, and the question becomes, is that an implied license to use their rights of personality, which were visible? And by the way, I think in addition to the the body cams and the audiovisual or the audio devices that Afroman owned, I think his wife, who was there, he was not there, also video recorded it on her phone. So there are 3 sources of video here, possibly, and I guess at least one source, I guess 2 sources, body cam and the telephone video of sound. So I'm not sure whether his audio system, or his video system, would record sound. I'm not clear on that. But in any event, he makes 2 clearly works of art. I mean, there's no question, but that music is original musical works are at the core of First Amendment protection. They may not be quite as exalted as books, but they're somewhere in there with books are the oldest kind of intellectual property around, at least legally. And so they get this premium protection. But movies are fully protected. Music videos are fully protected, which is what this is about. Certainly music as a whole is regarded as an art form, and art forms are clearly protected under the First Amendment, and the protection is pretty robust. I mean, it's hard to get beyond that. Now, for that reason, some of their attacks, I think, are not going to get very far. I think the attack on the use of whatever their rights of personality were in the music videos are likely to fail because they are so protected. And this is an original piece of music, and to boot, even though it doesn't affect most of your listeners who are not normally rated by the police, but this is commentary. His music videos are commentary on the behavior of police. So that would be accorded also a sort of an extra couple of points under the First Amendment because it is in the nature of political speech, which definitely is accorded the highest protection that there could be under the First Amendment. So he's criticizing official action, and that's very protected.
Let's just jump in here with a question, though. But why is one's right of identity superseded by in this case, artist First Amendment protections?
Well, it depends on how it's used. I mean, if it's used unfairly, and we had a famous case, although it didn't involve her image, but it involved Rosa Parks' name. And she objected to have her name. I think it was, I can't remember now, it was Iconoclast. I'm not sure who the group was, but the song was named Rosa Parks, and it was about going to the back of the bus, but what they meant was that the other rappers in their exalted milieu would have to go to the back of the bus because they were actually superior. And she lost that case. Now, now, would it have been different had they used an image of her? Well, no one knows because they didn't, and courts don't do that. But typically, as I say again, courts will go out of their way to protect artistic expression. Now, that's right there a gray area. What's art and what's garbage? And courts often will say, well, we don't make decisions like that. And I think they believe it. But of course, they are making decisions like that. Just as, for example, this judge in the Fox case is going to have to make a decision between a news organization and an organization that calls itself a news organization, the Fox Dominion case, that is. But the categories don't matter as much as the nature of the expression, which in this case is very protected because it's about official action. So this is not only art, but it's art that is satirizing the official actions of law enforcement people. And that is a terribly important matter.
Barry, it's really interesting that you talk about, the judges deciding what's art, because that's a crucial question, right? And there's a famous Tiger Woods case,
Mm-hmm.
There's a Stooges case where they came on opposite sides of that issue. I'm thinking of the argument with the Jack Daniels dog toy last week, right? Where I think it was Lana Kagan, or maybe it was Sotomayor, who said, I don't understand the parody here. So it's really interesting that you're allowing these judges, by the way, not probably are the most artistic people in the world if they've chosen this profession, ironically deciding what is art that's deserving of these protections and what isn't.
Mm-hmm. Well, as it moves more toward pure commercial speech, the First Amendment protection gets weaker, which is the next part of what I want to mention. Because while, there's other cases. I don't know if you know about that Three Stooges case where someone used an old picture of the Three Stooges, manufactured thousands of T-shirts with them on there with no license from anybody who then owned I think they were all dead at that point, but they had heirs. And in California and many other states that deal with entertainment heavily, with the most strange one being Tennessee because of Elvis. But there's
also the Birkin case from a couple of weeks ago that was very prominent.
You mean the bag, the Birkin bag?
The bag.
Yeah. Well, whether that is art or not, well, it's design. Yes, I think that would have because that is not simply a useful item. You're getting me into art law now. Where, for example, people wonder, well, how come these designs by Versace and all the other famous designers, 3 days after they're on the runway in Milan, they're on the racks in wherever, you name it. And how can that be? Well, that can be because they are useful articles. And while it may be that the pattern in the fabric is protectable, you can't protect the useful article. And that's been carved out of copyright and trademark protection because it is the courts don't want to limit the ability of people to make something in that strange shape, in that unstrange shape, I should say, where there isn't but you're right that the judges do get into exactly what they say they don't get into, which is dividing art from non-art and dividing commercial use in a film, for example, or in a music video from commercial use. And this is where I think Afroman may run into problems. And that is that once you start printing T-shirts and selling them, you begin to lose your protection for whatever your artistic endeavor is. Now, exactly when do you lose it? Lawyers will have a field day in court about this because, as a law professor of mine at Harvard once said, when does real property become personal property? How high do you have to throw a piece of dirt in the air before it's no longer real property? Well, it just shows the silliness of some of these categories. And it's also true in this respect that, if you only have 3 copies of an oil painting, that's probably still art. If you start selling T-shirts with and there are 5,000 of them, with that piece of art on it, that's a commercial use. Now, where is the line? No one exactly knows. The courts talk about another element which is very mysterious, which is called transformative use. Has the artist transformed? And Andy Warhol is in a continuing litigation over this because he used a photograph of Prince that was taken by a photographer. And therefore, the copyright was owned by that photographer. And he made one of his Andy Warhol, art pieces, but didn't change very much in the photograph. And so one court, at least, has said, no, that's not fair use. And yes, you have to pay royalties to the photographer. So that's still up in the air. It's gone up on appeal, and how that ends up will be a very important case ultimately. And you'll read about it because it's Andy Warhol. But that's another gray area. This whole commercial that spectrum between art and commercial speech is very fraught and really gray. And no one, at least of all the judges, are going to be very comfortable with the way they come out on this because they've been struggling with it for decades now. And the best they can do is talk about, quote, transformative use, but they never tell you, well, how much transformation has there got to be? And, if I just change the shadowing in the photograph, is that enough of a transformation? The artist, someone in Warhol's position or someone doing a music video will say, well, I did that because I wanted to show the sobriety or the somber nature of something or other. So I put more shadows in. Is that a good enough argument to make it art? I don't know. And the judges don't either.
So, Barry, you mentioned that the fact that Afroman was using these images commercially to sell T-shirts is obviously very relevant. Is the fact that he wasn't very successful at doing that? In other words, I think he sold about 50 by all reports.
So far.
Is that relevant? Does it have to be a real financial success for that to be a?
If I were the lawyer for the cops, I would ask everybody I know to go out and buy a lot of those T-shirts, so that I could use the number of 500 or 800, which will get me probably into the commercial use area and out of art. Again, I don't think you're going to be able to do that with the music videos, but with something like T-shirts or with posters or whatever else he's peddling, particularly if the prices are non-art prices. I mean, I think he's selling the T-shirts for like $50 or hoodies for $70. That's not fine art prices. Whether the courts will use the price point as an element, I don't know.
So it sounds like the officer's lawsuit may be not very successful, might not survive a summary judgment, but there might be some other liability for Afroman in using, as we talked about, the image of Peter Griffin from Family Guy. I mean, presumably, Family Guy did not give Afroman a license to use their T-shirt and to use their image in this way. So he might be facing other legal jeopardy on that angle.
Yeah, I mean, I would assume that Seth MacFarlane or one of his companies has trademark rights and certainly copyrights in that piece of cartoon art. One of the things that I was interested in, and I don't know this, I do like Family Guy and I watch it. I don't remember a lot of episodes that center around his being a fat slob, to use a negative expression. I don't mean to fat shame anybody. But, Peter Griffin is obviously a hefty character with a lot of weight around his middle. I just don't know whether that has been at the center of enough of what Family Guy is about to say that it could qualify as a parody use, in which case parody, a parody use of that image and therefore fair use. Again, an area that's a little difficult. The parody has got to comment in order to qualify. It can't just be sarcasm. It's got to comment on the original. That's what happened in the Acuff Rose case, the Pretty Woman case with Two Live Crew. The Supreme Court, determined that it was a commentary on the naivete of Roy Orbison's original composition. That it was basically referring back to Roy Orbison's composition as something that was made in the age of innocence compared to today, when we use four-letter words, a hint of stalking was shocking and all that stuff that it used to be, and it's not anymore. So whether Peter Griffin would qualify as a famously fat person, which would give him some support for saying it's a parody. I mean, if I were representing Afroman, I certainly would raise that and try to find some episodes where Peter Griffin was made fun of because he was heavy, either by his nasty boss or by his wife or whatever.
Last question here on the SERMAPod, Barry. You've been representing artists for years, and we've been covering alleged intellectual property theft by musicians here over the last year or so. They seem to be happening with greater frequency. My question to you is, are these lawsuits, are they happening more than ever, right? The idea that artists are copying each other or stealing from each other goes back as long as there's been popular music. Are these instances of alleged, piracy, stealing more frequent, or are the lawsuits just more frequent? Or are we just hearing about them more because of media coverage of them?
I think the latter two of the three that you mentioned. I don't know that they're Well, the lawsuits are more frequent. I don't know that recoveries are any more frequent, because one of the things that copyright there's two things. One, and I have a YouTube video on fair use, which I would commend to some of your listeners. But also one of the areas that's gray and been gray forever is, are you standing on the shoulders of the prior art and developing your own thing, or are you just stealing it? And there's a fine line again between those two things. It's possibly why the courts went to transformative use, because they wanted to see, they wanted to test the current piece of art by how different it is from the prior art. And so I think you have, and also, of course, because of social media, the explosion of social media and the use of it, I mean, more people know more about intellectual property than they ever did before. They're conscious of it. We get a lot of questions about, well, he stole my idea. Well, the Copyright Act says, almost in so many words, you can't own an idea. Because if you could own an idea, then every movie that is about boy gets girl, boy loses girl because he's an idiot, boy works very hard to regain her trust and succeeds, and they live happily ever after, you could never have anybody else produce a romantic comedy but the first person who did it, because they're all like that. So you can't own an idea simply because it ousts too much of the possibility of creating something new based, standing on the shoulders of those who've come before. And that's the distinction that you're talking about. There's a lot of misconception about that. People think that they can own an idea. No matter how many times I tell clients that, they come back with the same thing. In order to infringe on someone's popular music, which after all is usually only 3 minutes long or so, there's only 8 notes plus the chromatics, there's going to be similarities between those two. And the judges are in a position where they say, well, unless it's almost identical, we're going to say it's not a violation not an infringement. So, that's their bright line. It's got to be almost identical. Better yet, if there's an extraneous sound or something on the original that shows up in the second copy, because then they stole it. But short of that, there's going to continue to be these misconceptions.
That's Barry Oliver Chase from Chase Lawyers out of South Florida, alum of both Yale and Harvard. Barry, thank you so much. Next time you're on the show, we'll have to have some lemon pound cake available for you.
I would love that. I don't know about the lemon part, but I'm a pound cake fan. And if you can get Afroman to serve it, I'm with you.
Hey, back in the day, we could have gone to Wolfie's? Not Wolfie's. What was
Wolfie's.
Wolfie?
Pumpernicks and Wolfie's were the two.
Pumpernicks, absolutely.
Pumpernicks and Wolfie's, and now we don't really have I must tell you, and this is a shock to me, I happen to be Jewish, there's no Jewish deli in Miami Beach, of all places, in Miami Beach. There's a bagel store that's, sort of uptown here from where I am, but it's a shame, really.
Even Sage Deli has changed. There used to be Sage Deli over there in Aventura, and now it's called something else in Holland.
Oh, really? Okay. All right. Well, what can you say? We're all getting homogenized.
Well, from Two Live Crew to Two Live Jews, this is the SERMAPod saying thank you so much. We'll see you next time.
Okay, Rich. Thank you. Enjoy.
Thanks, Barry.
All right. Bye-bye.